Good morning, everyone. Can you all hear me? I know everybody's muted and off camera, but I want to make sure that you can hear me.
I can hear you, Marilyn.
Okay, I had a little bit of trouble getting in this morning, so my apologies for being what may be the last person on the call. Okay. So welcome everyone to this morning's member forum. We skipped last month, but we will be continuing this series of member forums for issues that are impacting the industry, things that are relevant for us to be covering. And this morning, we are happy to have on James Bradbury. James is with Fisher Phillips. Welcome, James. We have a couple of things that James is going to be talking about today. For those of you that are new to the call, I'm Marilyn Stansberry with IECRM. And Fisher Phillips has been a wonderful resource to us on a variety of topics. We started these member forums way back in the days of COVID and have continued them post-pandemic. And today, James is joining us to talk about the new requirements under the Colorado Privacy Act. There are also some additional laws that took place for Colorado businesses, things that you need to know that came into effect on July 1. James is a colleague of Kristen White, who has been a regular on these member forums. And James, welcome. Thank you for taking time with us today. If you have questions while James is presenting, feel free to add them to the chat. We will also open Q&A up following James's presentation to us. James, thank you so much for joining us.
Thank you, Marilyn. And can everybody hear me all right?
Yes.
Wonderful. So I'll have a PowerPoint presentation I'll run through, and I tested it out last night on Zoom, so I think we'll be in good shape. But thank you all for having me. It's a pleasure to be here. As Marilyn mentioned, my name is James Bradbury. I'm a litigation associate here at Fisher Phillips, and a general employment litigation practice. And my focus tends to be on trade secret, non-compete work. So I'm not necessarily an expert in privacy law, although we do have folks who are experts at our firm. But it's really one of the most interesting, intellectually stimulating areas of the law, and it's rapidly changing. So it's good to have a primer on it. And as Marilyn mentioned, this is going to be something of a two-part presentation because the legislative session ended, and as you might imagine, the legislature was busy passing more employment laws, 4 of which I'll note today. Yeah, so it's bright and early. I hope everybody brought their coffee. I want to acknowledge that it is 7:30, so if you're a little groggy, you don't have questions right away, no worries. So with that, I think we'll get started. So I'll try my slideshow here. All right.
And James, while you're
Yes.
setting that up, I will share with you that our own organization has had to go through some changes in our IT system, and we've seen impacts in making sure that we are compliant with the Colorado Privacy Act laws. We've spent probably the last 6 or 7 months working with our IT team to make sure that we are fully compliant. So even a nonprofit association, it has been impacted by these changes, which is why
Absolutely.
I think it's really important for our business owners to hear this information today.
Absolutely. And as you just mentioned, in contrast to some of the other states' laws, which I won't be talking about today, but I want to acknowledge that there are, Colorado is part of a growing trend. Colorado differs from California, most notably, in that the privacy law does sweep into its reach, its ambit, nonprofits. And so we'll talk about who's included and who is excluded when we get there. So is everybody seeing the full screen Colorado Legal Update July 2023 page and not my notes?
All good. We are seeing the presentation.
Wonderful. So again, this is my contact information on the screen, and it is available I'll throw it on at the end as well. So today's agenda, as I mentioned, we'll start with run through the new laws before digging into the Privacy Act. So 4 new laws to have on your radar. So the Power Act is the most consequential new bill that was signed into law. And that had gotten some traction in previous legislative sessions, and the proponents of it finally got it through this year. Also, some new equal pay obligations that are layered on top of what was some pretty significant legislation. Maybe 3 years ago now, with pay transparency and things like that. Expanded reasons for paid sick leave under the Healthy Families and Workplaces Act. Just some other things to note there. Then the Job Application Fairness Act, which relates to broadly speaking, age discrimination. And then dig into the Colorado Privacy Act and what businesses might want or should keep in mind when they're trying to comply with the CPA. And as Marilyn mentioned, if you have any questions, feel free to pop them in the chat, and I will do my best to answer them around the same time, but also have question asking period at the end. So we'll be covered there, and I hope to give you guys ample time to ask your questions. So noteworthy new laws. So these are new laws stemming from the most recent legislative session. First one, the Power Act. So the Power Act is an acronym for Protecting Opportunities and Workers' Rights. As the name of the bill implies, it's something of a worker-friendly law, as most of the laws coming out of the General Assembly have been in recent years, but particularly the last 2 or so. So tick through a few things here that the Power Act does. So one thing it does is it adds marital status as a protected class in Colorado, meaning that employers can't take any adverse employment actions against employees based on their marital status. And this law will take effect on August 7th. We fully expect that it will. I won't get into the minutia of how the Schoolhouse Rock, how a bill becomes a law and then actually put into place. But yeah, it'll be on the books and in force August 7th. Second, so in relation to that, action item number 1, take a look at your handbook policies, your training materials, and other written work product or other communications you have related to non-discriminatory practices to conform with the new law. And then the baseline, please don't make employment decisions based on marital status. Otherwise, you'll run afoul of the law and you'll be calling me, and nobody really wants to talk to me unless they have to, at least in my legal capacity. So that's action item number 1. Number 2, what the Power Act does is it makes it more difficult to use non-disclosure agreements. And that's a significant change, and it's in line, and I'll tell you how exactly it restricts companies' abilities to use non-disclosure agreements. This is policy point. It's in line with what the National Labor Relations Board and other federal authority what they've been doing to try to restrict the use of not only non-disclosure agreements, but non-compete agreements, things that limit employees' ability to, or workers' ability more broadly, to talk about conditions of their employment, to talk about particularly if they've been subject to allegedly discriminatory or unfair employment practices. So that's what the Power Act does, is it says that non-disclosure agreements, are colloquially known as NDAs, are void if they limit the ability of an employee or prospective employee. So again, you don't have to be employed per se to discuss alleged discriminatory or unfair employment practices. You can still have these, but it's very narrow. The only way they pass muster is if they meet some enumerated conditions. Most notably, you have to have an addendum signed by everyone in advance, the company representative, the employee or prospective employee who's to be bound, et cetera, that they have complied with the new law. And another thing to note is that the Power Act makes employers liable for actual damages and a penalty of $5,000 whenever they violate any of the NDA requirements. And this is on top of fees and other things that you might be subject to if you lose in litigation. So action item number 2, you got to be especially careful when using non-disclosure agreements in the future. And as with a lot of things, unfortunately, you probably need to work with an attorney to determine whether your existing template agreements are going to work under this new law. And then I'm going to be ticking through these things pretty quickly because we have a lot of ground to cover today. But such is life. The third thing to note, the Power Act imposes new record-keeping requirements on employers. So you have to maintain personnel or employment records for at least 5 years after either the record was made or received, or the date of the personnel action that resulted in the record, or the final disposition of a charge or discrimination, charge of discrimination or related action. And the law also defines personnel or employment record to include a number of enumerated things, including requests for accommodation, complaints of discriminatory or unfair employment practices, whether written or oral. You got to make a record, application forms submitted by applicants for employment, other records related to hiring, promotion, demotion, transfer, layoff, termination, rates of pay, which someone will note here in a moment, or other terms of compensation, selection for training or apprenticeship, and other such records. So some new record keeping requirements to take note of. As with any sort of requirements like those, work with your HR department and staff to ensure that one, you know what the requirements and obligations are, and also you're taking, you're actually taking the notes, recording and keeping the records that you're obligated to keep now. Then kind of the heart of the Power Act is this next point I'm going to make. So the Power Act really lowers the burden of proof for workplace harassment claims. And this is more a concern for, I suppose, the lawyers who are litigating workplace harassment claims, because the Power Act gets rid of a longstanding standard for workplace harassment claims and replaces it with a standard that we have all expectation is going to be easier for plaintiffs to prove. So before, where plaintiffs had to demonstrate that the harassment they were subject to was severe or pervasive to succeed on their claims, now they merely need to prove that they were subject to conduct or communication that was one, subjectively offensive to them. So, I was called a name and I thought that was offensive. And two, it would be objectively offensive to a reasonable individual who is a member of the same protected class. So if somebody is an employee or plaintiff is saying, hey, I feel discriminated against because of my sexual orientation or my race, some other protected class, they would need to show that I personally feel offended, but also somebody who is of the same sexual orientation or of the same race would also feel that way. And so it's not a true objective test where in law we often have the quote reasonable person standard, which is, you pick a random person off the street and say, hey, would that be offensive? In theory, here you have to pick a person off the street who shares the characteristic or characteristics plural of the person who is claiming harassment. So that's a change, and we'll see how this all shakes out. It's going to be subject to judicial interpretation and a lot of case law over, the next probably 5-10 years or longer to start hammering this out and seeing how the law takes shape. And then along with that, so the Power Act says that, well, look, we're going to make it clear that petty slights, minor annoyances, and a lack of good manners, not saying, please and thank you, does not constitute harassment. But then the law says those things can constitute harassment under a 9-factor totality of the circumstances test. And I won't go through all the factors right now, but that includes things like the frequency of the conduct or communication, the type or nature of the communication, how long was this conduct or communication, somebody being, allegedly harassed all day long. Was it just a comment in passing? Where this conduct or communication happened, notably whether there's a power differential that exists between the person claiming harassment and the alleged harasser. Was it, as you might expect, might it be a boss harassing a subordinate? Those sort of differentials are important, or I should say, recognized in the law. At the same time, the Power Act makes clear that to be actionable, the conduct or communication must have been made, submission to the conduct or communication must have been made a term or condition of the employee's employment, subject to or submission to, objection to, or rejection of the conduct must have been used as a basis for an employment decision, or you can still create a hostile or offensive working environment, kind of the old test. And there are some affirmative defenses that employers can take advantage of. Main thing is have a robust and followed harassment training program. So employers can say, look, we educate our employees effectively, and if they choose not to follow our policies and our procedures, our reporting mechanisms, it's not an absolute win for the employer, but it can certainly make it easier to survive these sort of claims under the new law. And so action item number 4, work with your legal counsel to determine how these standards might impact your future employment litigation. And that's very hard to do at the front end. Again, a lot of this is still to be worked out in the courts. But that'll be a discussion that you'll have with legal counsel in the unfortunate event that you do get a harassment claim. The next noteworthy thing that the Power Act does is it changes the standards for disability discrimination. And this is sort of a minute point in the grand scheme of things, but previously it was not a discriminatory or unfair employment practice for an employer to take an adverse employment action against a disabled employee if there is no reasonable accommodation that the employer can make with regard to the disability. The disability actually disqualifies the individual from the job. And then here's the key point. It used to be that the disability has a significant impact on the job. The new law says significant impact on the job is not sufficient. And now the defense only applies if the employer at issue cannot make reasonable accommodations that would allow the individual to satisfy the essential functions of the job. So just a little bit more worker friendly, but it's sort of a minute point, but something to keep in mind. So you're going to want to assess your reasonable accommodation procedures given this new standard. So that's the Power Act. Excuse me. So now we have some equal pay obligations as well. So as I mentioned, just a couple of years ago, Colorado was the first state in the nation to have some pay transparency. So pay transparency laws on the books. So now you see in job openings, it'll say a salary range, it'll say the benefits, things like that. That directly comes from the state's equal pay law. And so these new equal pay obligations supplement those pay transparency rules and clarify that employers must have similar transparency when announcing promotions with compensation and benefits information. And so for each job opportunity, which is defined as a current or anticipated vacancy for which the employer is considering a candidate or candidates, the employer must announce the range of the hourly and salary compensation, a general description of the benefits and other compensation. So that's not new, but then the date the application window is expected to close. So this new law incorporates internal job postings and job opportunities in a way that the old law, or I should say version 1.0, was more focused on external job postings. So your next action item, again, want to work with your legal counsel to make sure you have you audit your practices, your disclosures, your applications and postings, or your postings, not so much your applications, but make sure that you're in compliance with this new these new standards. It's not a sea change in the law like the Power Act, but it is important to note. And as I mentioned, there's some new vocabulary to keep in mind. So we have vacancy is both a newly created position or a vacated position. So it's not as you might think, a position that existed. You had somebody leave the role and now it's vacant. No, it's also new jobs as well. And then you also have things like career development and career progression. I won't sort of dig too deep on these, but to be mindful of really changes in really title, role, compensation, those sorts of things as promotions need to be more transparent. And here's another point to keep in mind. So within 30 days after a candidate is selected to fill a job opportunity begins working in that position, the employer has to make reasonable efforts to announce to the employees with whom the employer intends the individual to work regularly, said differently, coworkers, the name of the candidate selected for the job, the former job title, if the candidate selected was already employed by the employer, the new job title, and information on how other employees may demonstrate an interest in similar positions. I think the intent behind this law was in part say or to address situations where some coworker got picked for promotion over another coworker, and it feels like favoritism, or feels like a deal behind closed doors where there's not so much transparency. And again, you're going to want to work with your legal and HR team. So here's the next action item: to look at your entire internal hiring procedures so you can incorporate the new announcement obligations and disclosures into your standard practices. So again, the name of the game is transparency, trying to make it so that people feel like there was a fair process involved. Another new law. So we're all aware now of the Healthy Families and Workplaces Act, which has some paid sick leave categories, things that you can take time off for, that you can get paid sick leave for. And the new law expands the reason for that paid sick leave and includes things you wouldn't think of as sick leave, right? And so the current reasons you can use paid sick leave include what you might typically think. So the employee has mental or physical illness, injury or health condition, needs a diagnosis, care, that sort of thing, obtain preventive medical care. Relatedly, the employee needs to care for a family member who is in a similar situation, or the employee or family member has been the victim of domestic abuse, sexual assault, or harassment, and needs to be absent from work for purposes related to those such crimes. So it could be attending court, things like that. Relatedly, a public official has ordered the closure of the school or place of care of the employee's child, or of the employee's place of business. So again, we're moving away from what you might think of as sick leave, but the things that fall within the law's reach. And so now the law includes or adds if an employee needs to grieve or attend funeral services or a memorial or deal with financial and legal matters arising after the death of a family member, that the employee can take paid sick leave for that, to care for a family member whose school or daycare is closed due to bad weather, loss of power, loss of heating, loss of water, other unexpected event, or to evacuate their residents due to those same kind of, we'll think of, natural disasters or other unexpected events. So it's not just, employee is feeling ill and needs to stay home, or employee has a doctor appointment or needs to take care of a family member. Sick leave isn't just sick leave, even though the law calls it as much. So action item number 8, this will take effect August 7th as well. So, it's coming up here in a month. Update your policies to, your handbooks, things like that, to let your employees know what they're entitled to under the law. But you should keep tracking the use of sick leave. Record keeping is always your friend when it comes down to dispute resolution. So keep doing that. Then the last new piece of legislation before we dig into the CPA, the Colorado Privacy Act, is the Job Application Fairness Act, which limits your ability to inquire about a job applicant's age. And so this is actually set to take effect next July. So you have some time to comply, although I don't think it's the hardest one to comply with myself, but it the new law prohibits discrimination against individuals 40 years and older, and adds requirements to the Federal Age Discrimination in Employment Act. Nuts and bolts of it are, under the act, employers are prohibited from inquiring about or requiring an applicant to disclose the applicant's age, date of birth, or dates of attendance or graduation from school on an initial employment application. So if you have those boxes or fields on your employment application, you should get rid of those. There are some exceptions, but they're not, I think, terribly likely to apply unless you have, when you're required by a bona fide occupational qualification pertaining to public or occupational safety. My colleague Kristen, who does a lot of occupational safety. So if you have questions about that, she is the person to talk to. When you have to get it because of that is age, or some proxy because of federal law and regulations. And those are really the two to keep in mind. One thing to note here, which we'll see again in the Privacy Act, this act does not authorize, a private right of action. So, private civil suits where somebody would say, hey, I was discriminated against, or they asked me about, my date of birth on the job application form. So I'm going to sue. No, they have to file a complaint with the Department of Labor and Employment. And then the department will address, the incident or the or mete out punishment, the form of civil penalties. So there's not a private right of action. You're not going to be hit with, hundreds of individual suits, which is always a good thing. So your action item there, number 9, as I just mentioned, remove questions on applications and applicant platforms that inquire about an applicant's age. And so that's kind of the big thing there. So those are the new laws that employers should really take note of from this latest legislative session. So moving on to the Colorado Privacy Act. Then I'm not seeing, I have 3 screens here on my desk. So I don't know if I'm seeing questions. Marilyn, have I missed any questions? Have any popped up?
No questions have popped up related to the
Okay.
age piece that you just mentioned.
Sure.
I guess I thought that asking questions about age and went like I thought that was something we stopped doing a long time ago. So is there anything in particular, and maybe you said this about, and maybe it's just making sure that in documentation you're not doing anything to
Yeah.
inquire about age, because I thought that one was one that went away a long time ago.
Yeah, I think where I could see it becoming difficult or, tricky is, I think it also includes dates of graduation. So it's, so that's sort of a proxy for age, right? For some folks, you assume, oh, well, graduated high school at 18, and you go to college or other post-secondary education, perhaps, a few years later, that sort of thing. So that's why I can see it tripping people up.
Gotcha. So you can ask about educational attainment. You just can't
absolutely.
include years.
Yes.
Okay.
Yeah. So you're free to ask people, where they went to school, what they studied, all of those things that could well and probably should inform some employment decisions. You can't just say, hey, are you class of 95?
Right. So while we sort of before you transition on, why don't we give everybody just a moment to either unmute and ask questions on the labor and employment side of things before you move on to privacy. Is that fair?
Sure.
Okay. Feel free to unmute and or turn on your video and ask questions. Do you have anybody joining? Give everybody just a minute to collect their thought. To your point,
Sure.
it's still early.
It's a lot of information.
It is a lot of information, but this is great. I mean,
the 20-minute legislative recap.
Sure. Well, and we totally appreciate this. This is very important, and it is critical from an association standpoint that we're giving our contractors the information that they need, not only relevant to the industry specifically, but relevant to running their businesses. So it sounds like everybody on the call is good. I don't see anybody with a hand raised or nothing that's come up in the chat. So let's move on to the Privacy Act.
All right, will do. So complying with the Colorado Privacy Act. Colorado is part of a growing trend across the country. So this organization here, the IAPP, I think it's the International Association of Privacy Professionals. They have a wealth of resources about privacy law. And one of the things I found when I was putting together this presentation is, as of, last week, these are all the states across the country that either have introduced privacy legislation, passed privacy legislation, or where privacy legislation has failed. So Colorado was the 3rd state in the country to have a privacy act, following California's lead. California had their first big privacy law in 2018. Then Colorado and Virginia were both in 2021. So Colorado officially enacted the Colorado Privacy Act in July of 2021, but it went into effect only 11 days ago. So there was a 2-year ramp up period, both for the sake of folks who are subject to the law to get in compliance or to learn about the law, but also for regulators, particularly the Colorado Attorney General's office, to promulgate regulations and otherwise have that process run its course. So on top of the statute, there are regulations as well. And I'm not going to go into any of the regulations today, because this is more of an overview. And again, I'm not a privacy law expert, but that's something to keep in mind. It's a rather complicated and abstract area of the law. And so Colorado is part of a trend. There's probably little hope at the moment of getting a national privacy law. But you know, you can write your congressperson, I suppose, is the answer, and tell them that that's what you want. So does it apply to you? So some thresholds and some exemptions. So the Colorado Privacy Act, which I'll refer to as the CPA, applies to legal entities. The term of art for a lot of these is controller. That basically means an entity that has authority to decide what happens to collected data. You say, oh, we're going to sell the data, or we're going to use it in this way. That would be a controller. So we'll just think of it controller as a legal entity that conducts business in Colorado or produces or delivers commercial products or services that are intentionally targeted to residents of Colorado. If it's sort of like a jurisdictional test, can you sue the employer because they intentionally targeted the forum state? Similar thing here. And let's assume that everybody on this call does business in Colorado. If you then control or process the personal data of at least 100,000 consumers during a calendar year, you need to comply with the law. Or you derive revenue or receive a discount on the price of goods or services from the sale of personal data, and you process or control the personal data of 25,000 or more consumers. And here's a very important point. The CPA defines consumer as a Colorado resident acting only in an individual and household context. So we're only concerned about Colorado residents here, and explicitly omits individuals acting in a commercial or employment context, such as job applicants or beneficiary of someone acting in an employment context. So just because you have data from job applicants, those folks do not, count in your tally of either 25,000 or 100,000. So you do not need to consider employee personal data or job applicant personal data that you collect and process when evaluating the law's applicability. If anybody's familiar with other states' laws, particularly California, there is not a revenue threshold in Colorado's law. So California's, I don't recall the number, but you have to have a certain amount of revenue as a business to that's another prerequisite. Here, the amount of the number of consumers, Colorado residents, data that you're processing that really is the trigger. And then exemptions. So that big question number one, does it apply to you? But there are also groups that it does not apply to. So financial institutions, a lot of healthcare related data. It's not necessarily all HIPAA data. Some states explicitly say if you're covered by HIPAA, or if the data is covered by HIPAA, it doesn't count for purposes of the privacy law. Ours is a little more opaque as to that. Data governed by FERPA, so the family educational rights, educational data. And if you're subject to other privacy laws, if you're in like a highly regulated industry, like banking, like healthcare, things like that, you may be subject to other exemptions that would supersede your CPA obligations. And so when we think about, so what data matters? And so we have personal data, which is the real import of the law, and then some sensitive data. So personal data, and it's pretty broadly defined as information that is linked or reasonably linkable to an identified or identifiable individual. So if you can take the data and say, hey, this is James, or hey, this is Marilyn, based off of the data, that's gonna that's really what the law is concerned about. And again, doesn't include employment data, de-identified data. or publicly available data. So data that's publicly available, I don't know, perhaps like your trying to think of some examples, perhaps like your voter registration data, things like that, you would not have an obligation to keep secret. It's sort of like a trade secret, right? If something's out in on the internet, the recipe to Coca-Cola, you can't claim a trade secret in it. So if the information's out there, you can't claim that it's private data, or I should say personal data. But in addition to personal data, there's sensitive data, and that includes things that are particularly revealing, such as racial or ethnic origin, your religious beliefs, mental or physical health condition or diagnosis, sexual orientation, citizenship status, genetic or biometric data, or personal data from a known child. And the Act defines child as people under 13, or might be 13 and under. And you just have you have stricter obligations with the more sensitive data, as you might imagine. People really don't want sensitive data, being sold and otherwise disclosed without their consent, which then takes me into kind of in the heart of this from a consumer perspective, or from a general public perspective, is consumers have rights under this law. Main one is the right to opt out. And you can opt out of targeted advertising, the sale of your personal data, which we just talked about, what's personal data, or profiling and furtherance of decisions that produce legal or similarly significant effects. That would take a minute to unpack, so we'll keep moving along. But that's sort of the big thing, is you have the right to opt out as a consumer. And by next July 1st, the CPA mandates that controllers, which again, we're thinking of as entities that are subject to this law, they have to provide consumers with the right to opt out and a universal opt-out option. And the Colorado Attorney General has regulations as to the technical requirements for having a universal opt-out mechanism. So the idea is consumers will have the ability to click a button and say, by checking this box, I want to opt out of everything. And we've already seen a lot of this, I'll call it internet architecture in place. When you go onto many websites, it'll say, hey, I want to, I don't mind if that you track my cookies, or I want to only have the necessary data. Many companies are already subject to California's laws plural. So from a consumer side, you can kind of envision how this will play out. The consumers also have a right of access. So they have the right to confirm whether the controller is processing their personal data. They have a right to correction. So they have the right to correct inaccuracies in their personal data, taking into account the nature of the personal data and the purposes of the data. It's supposed to be a more transparent process, but also consumers are empowered to correct things. They also have the right to delete personal data concerning them, as well as the right to obtain personal data in a portable and readily usable format. You got to talk to your tech folks about how to make that happen. I mean, that's why technology services companies are I think pretty busy right now. So whereas consumers have rights, controllers have duties. And some of these are a little bit more abstract, and this is where the Attorney General's guidance will need to be incorporated and considered pretty closely. But the duty of transparency, meaning that controllers provide consumers with a reasonably accessible, clear, and meaningful privacy notice. And that often comes in the form of those click-through boxes at the beginning of your experience with a company or their website. But it's important. We're already at 8:15, so I'm going to run through these a little bit faster than I initially anticipated. But so controllers also have a duty of purpose specification, which is another way of saying they need to specify what exactly they're using the personal data for and what's being collected and processed. Also a duty of data minimization, meaning your collection of personal data must be adequate, relevant, and limited to what is reasonably necessary and related to the specified purposes for which the data are being processed. So you can't ask somebody for, all their blood type or something, or, mother's maiden name, social security number, all these things. If, you're just trying to, if they're a vendor, right, trying to get them a receipt, or contract with them. So you kind of ask for only what you need when you're asking for data. Also, duty of care. So you got to take security precautions in how you store and use data. And the more data and more sensitive data that you process and control, the more strict your security precautions need to be. Also, duty to avoid unlawful discrimination. That's, I don't know that that's anything specific to the Colorado Privacy Act, but they threw that in there for good measure. Duty to obtain consent for sensitive data. So again, we had that sensitive data definition, and things like race, sexual orientation, religious beliefs, the healthcare related data from children. You have to obtain consent for that. It means consent that is freely given, specific, informed, and unambiguous. It all kind of sounds the same, but under the law, those have slightly different definitions. So you got to be very transparent when you're asking for this sort of data. So now we look at enforcement. So, oops, you violated the law. Now what happens? So we talked about with the age discrimination statute, there was not a private right of action. Similarly here, there's not a private right of action for individual consumers under the CPA. So individuals cannot sue for alleged violations of the law. So who can enforce the law? Well, it's the Attorney General's office, who we suspect is going to bring most of the actions. Our Attorney General right now, Phil Weiser, he's pretty knowledgeable about privacy law, and actually his office was a big proponent of the legislation. So the AG's office plus local district attorneys, so the DAs in a given judicial district can bring actions as well. And so for now, once the AG or DA decides to initiate an action, the controller will get notice and then have 60 days to cure the violation. So you have a 2-month period to cure the violation without being subject to any penalties or additional action. But the right to cure has a sunset provision, meaning that I think it's going to be January 1, 2025, your 60-day right to cure goes away, and then you're just subject to actions from the AG or the DA. So big thing also to note, penalties. What's a right without a remedy if you're a consumer, right? So we have a violation of the CPA is considered a deceptive trade practice under the statute, and penalties are then governed by the Colorado Consumer Protection Act, the CCPA. So a non-compliant entity could be fined up to, and not to say you will be fined this amount, but up to $20,000 per violation. So it's a stiff penalty for non-compliance. But again, there's a ramp up period. There's 60 days right to cure for the time being. But yeah, it can be can be steep. So, and that action items. So call it a 3-step plan. And there are other things that your privacy professionals and, privacy is, both people from the tech side and privacy attorneys would recommend, but this is a basic overview. So step one, see if you're subject to the CPA. A lot of entities are not going to be subject to the Colorado Privacy Act because they're not processing or controlling, the data of 100,000 Coloradans or selling data and processing or controlling the data of 25,000 Coloradans. So that's the first thing to do, is see if you're subject to the CPA. And if not, this won't apply to you. But in the future, as data becomes more exponentially generated, even smaller entities could well find themselves subject to the CPA in the future, because these consumer number thresholds are not they're set in stone. They're not static. It's not like they rise for the pace of population growth or inflation or anything like that. So that's step one. See if it applies. Step two, revise your privacy policies. If the CPA applies to you, you're going to need to update your privacy policy or policies to talk about things like, what data are we collecting, particularly personal data or sensitive data, the purposes for which the data are being processed, how and where consumers can exercise their privacy rights. So who do they contact at the company if their data, if they have a concern about their data. If you're sharing data with third parties, what data are being shared with third parties, if any, the categories of data that are being shared with third parties. And if you're selling the data to third parties, so not just disclosing, but selling for targeted advertising reasons, you have to disclose that you're doing that, as well as the manner in which a consumer may then exercise their right to opt out of that sale or processing. So a lot to go into your privacy policy, a lot for your IT professionals and privacy counsel to have in mind. And then last thing, this is a little more future focused, but it's something to have on your radar. You got to implement that one-click consumer opt-out before July 1 of next year. And it's going to be a user-selected universal opt-out mechanism that complies with technical specifications established by the AG's office. And those technical specs are in force now, or should say have been announced. So it's just a matter of getting the bits and bytes aligned so you can do that and have the one click actually be an effective opt-out. So we have some, there are other resources. It's not just me. We have at Fisher Phillips a whole data security and privacy team. Many of the folks are California based, again, with California being the leader in that front, but these privacy laws are very similar in how they worked and the purposes behind them. So if you have specific legal questions, I'd encourage you to reach out to those folks. Again, for more informational things, and I want to say too, we're not the only firm in town that does privacy. So if you have other trusted counsel, talk to them too, because these are complicated laws. To learn more about these complicated laws and some of the technical specs, I mentioned the IAPP who produced that map. So the International Association of Privacy Professionals, they have a lot of resources. It's more geared toward privacy professionals, but it has some good information. And the AG's office, they have a whole section about the CPA. With all of that, what questions do you all have? And I'll do my best to answer. Otherwise, put you in the right direction.
Awesome. James, thank you so much for the presentation. Couple of things. Again, feel free to type something into the chat if you have a question, or easier than that, just unmute and perhaps turn on your video so James can see you, but at least unmute and you can ask your question. And while folks are formulating that, couple of things that I wanted to point out from your presentation, James. One of them was what you said about the duty of care. And that responsibility, that's something that we spent a lot of time talking to our IT provider about, and making sure that we had the right controls in place, not only internal to our organization, but external from, the vendor support that our IT company is providing. The other thing that we actually started doing this a couple of years ago, but if you aren't doing this, would be one of our suggestions regarding duty of care, and that is what James mentioned about third-party data sharing. One of the things that we do for those of you that are on the call, like our Flashpoint database, as an example, we have asked them about their privacy policies and their cybersecurity and their other, their other protocols, so that we aren't sharing our, and again, this was even before the Privacy Act was implemented. We just try to make sure that anybody that we're working with has the same kind of controls in place in their organization as we expect to have in our own organization. So if you aren't already asking those questions, it's something that might be helpful to you, just to avoid issues and problems down the road. Because I sort of feel like even if you aren't a company large enough to be impacted, the person that you are sharing data or that's processing data for you, they might be subject to it. And so that's just a one more extension that I would say would be important to think about.
Definitely. Yeah. Thanks for bringing that up. That's an important thing to note for some of the smaller entities out there.
Yeah, that even if it doesn't apply to you, it still might in a conglomerate if you're, part of a larger coalition or group or something that, or working with a vendor. And again, I don't know that that's specifically part of the law. We were doing this even before the law. We're just trying to do everything that we can to make sure we're protecting data, because you all might have noticed that I went on mute at the very beginning of the call, and it was because I received a phone call about some potential fraud charge related to a credit card, and that was work related. And I muted and covered my video to take the call, but you just never know when something potential, when somebody's going to try to make a breach. So, but all good on that specific thing. James, thank you again so much. We appreciate you presenting this information and going on over not only the new laws, but the Privacy Act requirements. And if possible, we would love to be able to share the slides with everyone that have been on the call. I don't know if you would be willing to send us your presentation, but we'd like to do a little wrap up for those that have participated or for those that weren't able to join us, and we can send that information out to the participants if you're willing to share.
Sure. Yeah, I can do that.
Okay, awesome. And then we'll also include your contact information for anyone that has additional follow-up questions or needs information. And the only thing I have to share, we're right at the 8:30 hour. It doesn't look like we've had questions come in, but the only other thing I would share is that next Monday is the deadline for the IEC National Awards. So for our contractors that are on the call, if you won a Summit Award, if you turned in a nomination for a Summit Award, or you missed that opportunity, this is your next opportunity to apply and submit for a national award. And we would love to have as much participation from our contractor members and our partners as possible. So if you have any questions at all about filling out that application or accessing that information, please reach out to me or to Holly, and we would be happy to step you through the nomination process for national. It's the same platform that we use for the Summit Awards, so it's super easy to do a submission. With that, we will see you back in August for the member forum. And if you are a golfer, make sure that you've signed up to play golf with us on August 31st. And James, thank you again for taking this hour along with your prep time to share this important information with us.
Absolutely. Thanks for having me.
All right. Thank you, James. Thanks all. Have a wonderful day.